tinha? Já, cadê o Lucas? La exposición.
Está lista.
¿Ah? ¿Está aquí o está allá?
Está aquí y está allá.
Sí, sí, sí. Estamos chegando no nosso último seminário e eu gostaria de agradecer muito ao professor Andrés Guadamus por ter deixado seus afazeres na Inglaterra, na Universidade de Sussex, e ter vindo para o Brasil. Eu vou falar em espanhol com você porque sei que tu lo puedes compreender perfectamente. En mi clases en este último semestre hicimos investigaciones sobre inteligencia artificial. Y el profesor fue uno de los expertos que tenían artículos, papers about this, sobre esto. Entonces, las personas que aquí están tienen conocimiento previo de su pensamiento, discutimos tenemos que hacer esto sobre la propiedad intelectual de la inteligencia artificial, si es del usuario, si es del ¿no? Y mientras tanto, me gustaría decir que es un honor y un placer para nosotros que tú estés aquí. Y bienvenido a Curitiba, a nuestra universidad, a nuestro grupo de pesquisa. Y esta es su casa, su clase, sus alumnos. Muchas gracias.
Muchas gracias. Voy a ver con este, sí, está bien. Muchísimas gracias. Profesor Marcos, ha sido todo un honor el que me hayan invitado aquí. Me siento muy en casa, me siento muy contento y me ha gustado mucho. Voy a dar la clase en inglés porque no hablo español jurídico ya llevo 20 años en el Reino Unido y nunca he escrito ni he dado clases en español en esos temas, así que me manejo un poco mejor en inglés en el tema. Ok, me dieron toda la tarde, pero no puedo hablar toda la tarde, sería muy malo para ustedes que me escuchen toda la tarde, así que voy a hablar un poco menos. Voy a pasar ahora al inglés. This paper is actually a paper that you're going to be the second audience that has seen this. The first one was in Barcelona. The paper, I'm writing it was in Barcelona last year, and amongst the audience was Jane Ginsburg, and one of the biggest honors of my life was actually to present to Professor Ginsburg. She disagreed with everything I said, but that was good. That's on par with, that's actually very good, that she was interested enough to disagree with me. That was always very nice. Anyone that has met Professor Ginsburg will know she's. I'm always very honored. So you're going to be the second audience that is going to listen to this. The reason for this, I'm writing the paper, and it's one of those papers that I cannot finish. The more I research, the more I write. The more I write, the more I research. The more I research, it's become to the point that I have to finish it. So it is about artificial intelligence, but it is mostly about the other topic on artificial intelligence, which no one has, or not a lot of people have written about. I've just reviewed a paper that is going to be in a chapter in a book edited by Professor Séverine de Soulier in France. Is the only paper that I know that is going to be dealing with this from a liability perspective, from the perspective of copyright infringement. So first of all, let's get this out of the way. I'll be very happy to answer questions on authorship. So if you missed the presentation, it was at 9 in the evening on Monday. So previously in Coraip, let's say like let's do it like a Netflix show. I talked a bit about the ownership question, and my ideas have always been that I think that we should look at the the authorship question on a case-by-case basis. And therefore, we should have a general rule that allows the possibility of having authorship by artificial intelligence. And I think that the UK's provision in this respect is quite a good example. It erases the question of authorship. It erases the question of whether or not the machine did a lot of the work, and it puts the question where it should be. And the question should be about originality. Is the work original? And that then we have all of our standards of originality all across the world. But I think if we have a provision that at least allows and permits the creation of some copyright work, that should be enough. And then we can go and say, all right, this painting this should not have copyright. You did not do any work. In this situation, I think this merits copyright protection, et cetera, et cetera. The options that we have, of course, is to have no copyright, which is everything is going to be in the public domain. That is a possibility, and I'm happy with that. I'm not completely against, and I understand that there are very good reasons why we should not have any type of authorship for artificial intelligence creations. I agree that there are good arguments made against it. I am afraid that we may encounter ourselves in a situation where we are competing, where real creators are competing against free works. So I gave lots of examples on Monday night. Now it's possible for you to get people that do not exist, like faces and artificial intelligence generated faces. So you don't need to hire models anymore. Just yesterday, I was testing some of the newest predictive software, GPA2. They just put it completes the sentences, but it's amazing because now they just released a couple of days ago the full implementation of GPA2, and it is amazing. I tweeted a couple yesterday, but I'm going to show you just a couple of examples here. Let's see. I need to move this one here. I just put Andres, and it said Andres Martinez, 26 of Phoenix, was shot dead. So, oh my God, I'm dead. Well, it's not Martinez, but you see, this was generated by this artificial intelligence just with one name. We are entering a stage where things are going to get, I mean, the grammar is a bit clunky. I would say probably it could take some editing. You can start creating believable journalistic articles based on a few sentences. And a friend replied and created this. The panda looked to the horizon. It saw a country still wholly unnecessary filled with blockchain enthusiasts with Intel computers on their desks. This could not continue, thought the panda, and so it began the panda's campaign of destruction, etc., etc. This is the bolded is what my friend put, and everything that follows is generated on the spot by the artificial intelligence of GPT-2. It is getting to a point that is scary. When I started looking at this and I started playing with this, the website is down, by the way. I tried to have a live demonstration of this is completely dead. So it's getting scary. It is going to be a game changer, I think, for fake news. You can now write believable fake news text. Okay, this is the state of authorship. We are going to, my argument is that we are going to be competing against all of this flood of free music, free photographs, free text, and we have to decide as a society, it's fine, it's free because it's in the public domain. So what is the role of the human creator? Is it more valuable? The human creators are going to become more valuable sought after because they can generate better works. Let's be honest, I mean, just listen to the radio and your average reggaeton, you can be an artificial intelligence that gets it better, exactly. Sorry, showing my age here. I still like, I like some reggaeton, but old-fashioned reggaeton, everything after Gasolina is not really, it's not really reggaeton. But anyway, yeah, Despacito, come on. No, sorry, but if you like Despacito, I don't. Okay, my idea then is to propose this case by case and the authorship debate. Okay, I'm happy to discuss this, and if anyone wants to answer to ask any questions, because I'm going to start switching to authorship in a second. Sorry, to infringement in a second. Anyone with ownership? You're fine? I see Pedro, yeah? Okay. We can come back to the ownership question in a second, but if you want, yeah.
I just want to hear the full answer and that we were talking before about the data mining exception and the thing about the works used for the development of artificial intelligence are tendentially, meaning the court's decisions tends to say they are exceptions for copyrights, but the works they produce are still protected by copyrights.
Yeah.
And
I am going to get to that. If I haven't answered that question, I'll get to that. Okay, so that's generally my idea, to have this on a case-by-case basis, and maybe take a look at authorship again, that we don't need human authors, and one of the cases that I like is this US case involving aliens and dead people, the Urantia Foundation and Mahera. And maybe artificial intelligence rights in the future. Let's start thinking about that. Okay, so I'm going to start now with infringement. And I always start with an apology with all of my presentations. And the apology I sort of already told you, this is a work in progress. So any input that you can provide, I will be more than happy to listen to your input. If I say something stupid, please correct me, and I'll be more than happy to listen to your ideas, because I think this is very, very new subject, and there hasn't been a lot of work on the infringement side. I have it on good authority that some of the organizations that are working on artificial intelligence are not interested in authorship. I'm talking about Google. I've heard, I have a really, really good friend that is one of the Google lawyers, copyright lawyers in Europe, and he told me, we don't care. We're Google. They don't do ownership. They don't do authorship. They don't care. They can release everything on public domain if they want. Their business model is different. Their business model is artificial intelligence, and they want to train the artificial intelligence, so it doesn't matter if all of the tools are not owned by anyone. What they're concerned about is the infringement question. Why? Because everyone wants to sue Google, right? Everyone, absolutely. Yeah, absolutely everyone wants to sue Google. So at some point, someone is going to sue them for an intellectual property question. Sorry, for an artificial intelligence infringement question. So I'm going to try to frame the question here. Now, I do want to make sure we're talking about the same language. Whenever people are talking about artificial intelligence, chances are people tend to confuse a lot of these concepts. And it sometimes bothers me when people say, oh, AI creativity, and they're talking about one of these things and not about the others. So it is very important that we have clear idea of what we're talking about. Because when we are talking about artificial intelligence, we're talking about artificial intelligence in several aspects. The algorithm. So the algorithms themselves are not protected by copyright. At the best, you may get a patent in some countries that have protection for algorithms, but that's tricky territory. I know that some algorithms have been protected in the US, but after Alice, it's more difficult. So let's assume that the algorithm itself, the idea of how to train a machine is going to be public domain. Okay, let's start with that. Second, the software. The software is different. It's protected by copyright, literary work, no problem whatsoever. But the software is not the output, and I'll get to the output later. But please never confuse, and this is very common. Lots of people generally confuse the software with the output. And we're talking about artificial intelligence. They say, oh, but it's public. No, it's under an open source license, and I can do whatever I want. But that's the software, okay? So the software is the code implementation of the algorithm. In the case of GPA2, for example, it's a very specific type of software code. GAN, the generative network, adversarial networks, thanks. After lunch, my brain stops working. Generative adversarial network is another implementation software. There are lots of different versions of GANs, and most of them are on open source software. The data itself is an entirely different issue. So the data is the specific bits of information or points of information that are going to be fed into the software to create a data set. Data, for the most part, is not protected under copyright, right? You cannot protect information, generally. We have prohibition. Lots of jurisdictions have the same prohibition. You cannot copyright data as such. Sometimes you can have data points or specific data that could be protected under copyright, photographs, text, etc., etc. But as a general rule, data as we know it, zeros and ones and bunch of numbers are not protected, okay? Data sets themselves are going to be protected. In some jurisdictions, you can have protection under copyright. In others, you could have potentially the protection under the European database right? But sometimes we can argue on whether or not a specific data set is going to be protected. Most of them, anyway, are protected by contract law. A lot of data sets, to bypass the question of ownership of the data set, they say, we don't care about the intellectual property. If you use this data set, you are going to sign up, click here to agree to terms and conditions that we are going to set out. And so they often bypass completely the ownership question, and they go directly to contract law. Lots of data sets are protected with behind a paywall under just by contract. So they tell you, you cannot reuse this for commercial uses, you cannot reuse this for X, Y, or Z, not because they own the data, but because you agreed, because you signed a contract when you entered and you agreed to download this data. I can show you example after example of companies that are doing this. IBM, they're not stupid. They're generally going to have most of their data sets behind a click wall. Okay, so you click, I agree, you agree, you own, you cannot use this data set for whatever purposes. And then the output. The output is what everyone always thinks. The output is the picture, the music, the text that I showed you right now. That is the output. That is the end result of hundreds and hundreds and hundreds of hours of programming and feeding machine learning, et cetera, et cetera. The output, I think that's where the ownership question and the authorship question has rested, with the outputs. And I would actually think, even though I've written about outputs and I've written about authorship, I would say that, and I'm going to argue that this is not the most interesting legal part. Okay? Because it's only dealing with one element of the question. So, what is the question? What is the problem? I am putting it in 3 ways. The problem of infringement is as follows. First, an autonomous agent infringes copyright on its own accord. Okay? Second, data set infringes the copyright. So the actual data or contained in the data set or the data set itself. And 3, derivative work, the output that I was talking about, is actually infringing copyright. Okay? I'll explain each one of these, and whenever you see a cat, I'm changing topic. So this is actually a cat in a Roomba, so it's very topical. Okay. First is the liability of the autonomous agent. All right? And this is what people think about when you talk about liability of artificial intelligence or autonomous agents. Obviously, Kit and Hasselhoff with his amazing hair, you know, yeah, it's very 80s. Sorry, you probably don't know this. It's Knight Rider. Okay, the car was an artificial intelligence. He talked, and he was very cool. So most people actually, generally, when you're talking about liability of AI, this is what they think about. They think about self-driving cars. Okay, this is a self-driving car-free zone, but I just wanted to get that out of the way. I actually think that probably the future, the regulation of self-driving cars is not going to be as interesting because it's all going to be handled by insurance. It doesn't matter, you're insured, the company that made the car is insured, the software manufacturer is insured, let the insurance fight amongst each other. That's how things are handled now anyway, okay? I got interested in the liability aspect actually when I read this book, and particularly the liability of autonomous agents. It's a book by Charlie Strauss called Rule 34. It's a fantastic book. It imagines a world of augmented reality, so everyone has augmented reality glasses, and you can see, I could see everyone's name in this room with my augmented reality glasses, and if I had access to the proper databases, I would know your grades, your insurance rating, your health rating, what you ate yesterday, where you were, et cetera, et cetera. You know, that it's an interesting from that perspective. But I was very interested from another perspective. It is this describes an autonomous agent, which is a spam killer. A spam killer robot. It's a sophisticated artificial intelligence robot that decides to think that the most efficient way to fight spam is to kill spammers. So it says, okay, it starts hacking into IoT devices and starts killing off spammers one by one. So it worked, you know. It killed a lot of them, and then the police is trying to find out who is behind this, and only to find that it's actually an artificial intelligence that is committing the crimes. Fascinating book. It should be made into a movie. Exactly. Yeah. It involves all of the IoT devices becoming killer devices. It's fantastic. Okay, I became interested in that. It's not as far-fetched as you can possibly imagine. This is Media Group Bitnik shopping bot. This is called a darknet shopping bot. It's a robot that in 2014, in October 2014, was programmed to go to the darknet and start buying things with Bitcoin on the darknet. And it bought drugs. So you can see them here. They arrived on the mail. So the bot broke the law, right? Who is responsible? The bot was arrested, funnily enough. The police took away the computer, and eventually it purchased the drugs, and they confiscated the bot, but then was released. Because it was considered to be an artistic project, and there was no mens rea, of course. And I'm not a criminal lawyer, but I think that in the end, they could not allocate the responsibility to a human. Okay. When it comes to copyright infringement, this is not new either. So robots have been what we would call an autonomous agent, have been infringing copyright for decades now. Okay. What is a web crawler? A web crawler is an autonomous program that you let it loose on the internet, and it copies text from the internet, right? So in the strictest sense of the word, it is infringing copyright. Correct? Yes? No? Maybe? Okay. We have had already lots of ways of dealing with this. So the law has already been changed to accommodate this. One of the ways, now we have specific exceptions and limitations for this in Europe. I don't know in Brazil, but do you have something akin to this? So we have in the directive, in the Information Society Directive, Article 5.1, for example, creates an exception for temporary copies. So if you have a copy that constitutes an integral and essential part of a technological process, and it's a lawful use as well, you can infringe copyright if it's for temporary use. So it's also, it doesn't have independent economic significance, and this is quite important. A web crawler doesn't, the web crawler is not copying a website in order to sell it. It is a technological process. So we do have already in the books, in many legislations, in many jurisdictions, ways of dealing with autonomous agents that are infringing copyright. Okay? So far, so good. Everyone is happy. I don't know, in Brazil, do you have something similar to this? Yeah? Okay, excellent. Yeah, because so generally it's accepted for things like you can have caching as well. Cache provision in which you can create also a cache copy. Your computers are filled with copies of every web page that you have ever visited. It makes the internet faster. The web works with content management systems that allow, all of these systems allow you to get the Instagram photograph in seconds, almost breaking the speed of light. All of this is because there are cached copies of lots of content in servers located near to where you are. Okay, so all of this is now accepted, so we don't have a problem. We also have at least in several countries, increasingly, we are having the exceptions and limitations, and that's where, Pedro, I'm hoping I'm going to answer your, oh, thank you very much. We're going to answer your question. This is going to be the part, text and data mining, it was considered to be enough of an interest for the state, at least in the UK, that we have now an exception specifically for text and data mining since 2014. This was actually created for a very easy reason. David Cameron, who we have to blame for Brexit, one of the good things that he did was that he became friends with Eric Schmidt of Google, and he had dinner. Apparently, the story is that they had dinner, and he told him, "You know, your copyright law could use some revamp. You know, you should change your copyright law." And he gave David Cameron a list of things that he liked and he wanted, and text and parody was one, private copying was the other one, revamped exceptions and limitations for archiving, including web archiving, and most importantly, a text and data mining exception. So we passed, I think that we were the first country in the world. I'm saying we because I'm Costa Rican, but I'll be fully British in about 3 months or 4 months, depends on when I swear my fealty to Her Majesty the Queen. Yeah, I'll become a subject. That's one of the reasons why I didn't want to do it. But well, okay, let's get some water first. Thanks very much. Okay, so we have this exception in UK law, and it's very specific. It's for text and data mining for research purposes and with no commercial purpose. And it also must be accompanied by sufficient acknowledgement. So very good. I also have it on good authority, and this is from the UK IP office, that this exception, at least it hasn't been used a lot, not that the IP office knows about. So they had a couple of exercises and with stakeholders, and they were saying that they were not applying that much. Lots of researchers are still afraid, a bit afraid, but at least the provision is in the books. Okay, that is the first. Japan followed suit, and they created a very interesting broad exception, which is, as you can see, I'm just going to read it. For the purpose of information analysis, blah, 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 that's usually images, and this is very broad as well. It includes images, sounds, languages, images, and other elements constituting such information from any works or other such information. And to make a comparison, a classification of or other statistical analysis of such information, the same shall apply hereinafter in this article. By using a computer, it shall be permissible to make a recording, there should be an A there, on a memory, or to make adaptation, including a recording or a derivative work created by such adaptation, of a work to the extent deemed necessary. Do you notice something in this exception? No research question. There is no research requirement, and no non-commercial requirement. So this is extremely broad. You can do text and data mining for commercial purposes, as long as it's permissible that you make the request. Usually what that means is that you have lawful access to the work. It's text from the internet, or images from the internet, or images from Flickr, or something like that. So it has to be lawfully accessible, therefore you can do text and data mining on it. Okay. So you cannot enter and break into a system that you don't have access to for the purpose of this. You have to have lawful permission, and that's quite important. Okay. Japan has done that. Much to my surprise, the only good thing that came to come out of the Digital Single Market Directive is this. And much to my surprise, we're still in the European Union in the UK, so I can still analyze this. The Digital Single Market Directive actually has, amongst all of the things that we don't like, Article 13 and Article 17, we have an exception for text and data mining. Article 3 says, exception for reproductions and extractions made by research organizations and cultural heritage organizations in order to carry out for the purposes of scientific research, text and data mining of works or other subject matter to which they have lawful access. Again, same thing, research institutions, scientific research, and lawful access. So you cannot break the law in order to, so you cannot enter a database that is protected behind a firewall. Okay,
Article 4, exception for reproductions and extractions of lawfully accessible works and other subject matter for the purposes of text and data mining. So that's also, it's a much broader one. This is for commercial uses, but you have to, the owners can opt out of this. So they can say, yeah, by contract, exactly. So it's interesting. It hasn't been implemented just yet, and we have no idea how they're going to be implemented, but at least it's in the books, okay? And in the US, we have fair use. Google Books case, one of the important aspects of the Google Books case is that it allows at least text mining for non-infringing fair uses. If you know the background for this, there used to be this thing called Google Books that I think they're still available, but you cannot see the entire book. You can see only like parts of pages of the book. Yeah, but what happened was that some companies were getting, Google was scanning books from libraries and entire books. And the Society of Copyright Authors in the US, obviously, they don't like this, and they sued for copyright infringement. Google defended themselves that it was for use, and they mostly won. So Google's unauthorized digitization of copyright-protected works, creation of a search functionality and display of snippets from those works are non-infringing fair uses. I'm not going to read the rest, but the final part is important. Google's provisions of digitized copies to the libraries that supply the books on the understanding that the libraries will use the copies in a manner consistent with the copyright law also does not constitute infringement. So you can create copies of the libraries for your copies in the libraries, and it's not going to be infringing. So this is just the first question, but this is my conclusion. Infringement will likely fall under many existing limitations in some jurisdictions. If you don't have this these exceptions, you're out of luck in your jurisdiction. So maybe you may want to start thinking very quickly of getting them in your books, at least, if not temporary copies. I think text and data mining would be, I think is going to become the international standard. Cumulative copy may not amount to infringement. I'll talk about that a bit later. And maybe an idea that this is not my idea, a researcher thought about this. If a robot or an autonomous agent is infringing copyright, maybe we should revisit the Roman law of slavery. You could actually think of autonomous agents as slaves. As, it's a servus non habet personam. The slaves are not people. So actually, there was a very complex legal edifice on trying to allocate responsibility for those who do not have legal personality. Okay, that is the first point. Any questions so far? Okay. The second one, data set infringement. What are the issues? You need to have access to vast amount of works in order to train the artificial intelligence. That is what artificial intelligence means. And this could infringe copyright. Can copyright owner of such work sue the AI creator for hosting and analyzing large amounts of data? That is the legal question. In other words, can I sue Google because they are hosting, they have been making analysis in some of my images? Okay, that is going to be the question. This is going to presuppose 3 or 4 different issues. You can use public domain works. So in order to bypass the question of ownership and infringement, lots of companies, what they're doing is they're only using public domain works to train their artificial intelligence. So old books, the Gutenberg Project Gutenberg texts, old paintings, etc., etc. So a lot of the works that you're starting to see are being trained with old paintings. That's quite interesting. You could use works with permission under some sort of license. So some other companies are actually trying to do this with licensed works. I'll show you a couple of examples of this. You could rely on exceptions. That is living a bit dangerously, in my opinion. You are opening yourself to being sued at some point. Or you could argue that you're actually not infringing copyright. And you could say, I'm not even infringing copyright. Okay, I'm going to show you several case studies on this to make things a little bit less legal and more eye-catching, I guess. The first is a huge data set called Diversity in Faces. This is an IBM project, and this is created, it's a large data set of about 1 million faces that tend to have, they were taken from Flickr. So if you know Flickr, Flickr is, most works in Flickr are under a Creative Commons license. So they, the initial data set was actually released by Yahoo. It was about 10 million pictures in that initial data set, and they released all of these pictures that were under a Creative Commons license. IBM took only the portraits, only the faces, and they also curated it to be diverse faces. Let's say artificial intelligence had a diversity problem. It worked really well if you were a white male, and it stopped working if you were a person of color or you're female. So at some point, and if you were both, it was worse. There's fantastic video, by the way. I should have looked for it, where there is this artist, and I can't remember her name. She has a fantastic poetry. She's a black woman in the U.S. Declaiming poetry that the artificial intelligence doesn't recognize her. So it recognizes her as something else. And lots of examples where black women were being misidentified, and it is very, very powerful. I'll try to look for it in the break. Okay, so this data set is now stored by IBM, and you can download it, but in order to download it, you have to click on very lengthy, and I'm telling you lengthy, I went through it word by word, agreement. And it says, we do not own the images. They are released under Creative Commons license, but you should check if your use is breaking copyright law in your jurisdiction. So, but I still think that they're going to get sued at some point. Yeah. Oh, fantastic. Image rights is not harmonized area of law. If you're a celebrity, you're generally quite well, because lots of image rights legislation that we have is protecting celebrities. So in the US, their personality right, what is it called? It's not a commercial right, it's a publicity right. It's mostly for celebrities, and in California specifically is very strong. In the UK, we have passing off, where some celebrities have won cases of people that were trying to pass off or sell products in their name. The test case is Rihanna. Rihanna, there's a famous shop in the UK called Topshop. Topshop was selling Rihanna t-shirts, and she sued them for passing off because she had not agreed for her image. They had copyright, they were permitted to put it because it was, they were licensed of the copyright, yeah, the photograph. But she sued because it was her image, and she won. In Germany, we've had several cases. One of my favorite is, but not for celebrities, so Germany actually protects wider. I don't know if you know Techno Viking. Anyone? This is a really old meme. If you really have to know your memes to know Techno Viking. Techno Viking is, oh my God, what do they teach kids these days? Come on. You don't know Techno Viking? Oh. God, I feel like I have to teach you now. Techno Viking, let's see. No, you're going to see. You're going no Viking. Oh, got it. Missing an H. This is fantastic case. Okay, let me pass this here. I'll just turn on the mirror. Okay, that's Techno Viking. If you want to spend a really good 5 minutes, you should download the entire video. The music is fantastic. This guy is in 2000. There was a parade in Berlin called the F parade. Imagine what F stands for. And it was a big techno parade because obviously Berlin is the capital of techno. And this guy was, let's put it this way, it was off his rocker with drugs. He starts dancing and the video, and this filmmaker recorded the entire thing. He uploaded it. This is even before YouTube. So YouTube was not even really in existence. And it lay dormant until 2007 when it got uploaded and it became one of the first modern internet memes. Everyone was wearing Techno Viking, and it was Techno Viking this, Techno Viking that. There are lots of just look at the memes, it's amazing. And all hail Techno Viking and all sorts of things. And he, the filmmaker put it on YouTube, and he got 10,000 euro from YouTube. So Techno Viking sued for image rights, and Techno Viking won. We don't know Techno Viking's name, so you can always refer to Techno Viking as Techno Viking, and he won. But he won only the. I can show this, but the filmmaker cannot show this because he only won the injunction for that one video. So there is an injunction on the one video, and the injunction, and he had to pay the 10,000 euro that he had made on YouTube, and it was fantastic. And he made the filmmaker has made a documentary. So it's not, to answer that is a non-harmonized area of law, which I love image rights. I teach a class on image rights, so you can probably tell that it's one of the subjects that I love the most. Okay, sorry. Now you know Techno Viking, and you can tell your friends, if you don't learn anything else from this class, you'll become Techno Viking enthusiast as much as I am. But yeah, to answer your question, because it's not harmonized, you may or may not get protection, and it's more difficult for people, normal people, non-celebrities that are contained there, to enforce their image rights. Maybe in countries like the Netherlands and Germany, it's easier. But for everyone else, it's not easy. I don't know, what's in Brazil? What's the image rights in Brazil? Do you have? Ah, it's interesting. So, but they are a bit protected. Yeah. Thanks. That's. I'll have to include Brazil in my next class. Thanks. Oh no, that's fantastic. No, please do. I've been teaching on the subject, but I haven't written yet. But that's going to change because one of my next papers is going to be on image rights. I think I want to have image rights to fight deepfakes, for example. So that's another idea. Okay, I have too many ideas, so little time. But that's yeah, it's impossible sometimes. Okay, so we have diversity in faces. There is no legal action yet, but you could argue that a lot of the, as you can see, this is actually the breakdown of the licenses in the data set. You will notice that lots of them, a large majority is actually non-commercial use, right? So if you're using it for commercial uses, the images, what does that mean? That means that you're in breach of the license, and if you're in breach of the license, you're infringing copyright if you're using it. That's when you're in breach of license, you're going to infringe copyright. Therefore, I would say that IBM are just waiting for someone to sue them, and this could happen very, very soon, because this was in the news quite recently, and lots of people got very upset. Particularly because this data set is being used to train face recognition for immigration purposes, because it's diverse. Diversity is not always a good thing. It's being trained so that ICE can deport people that look like me, that are living in the United States, Central Americans usually. Okay, so that's. Stay tuned, I guess. There is no legal. My argument has been that they are actually living in dangerous times. I can see how someone could make a very good case that if these data sets are being used for commercial purposes, Yahoo, IBM, and whoever is using the artificial intelligence are going to be infringing copyright on that specific image, because it's included. You can download them. You can. They're actually included. Okay, that's interesting one. I know Professor Hilty said yesterday that we should stop. We should. We should stop. Yeah, he didn't like it. I disagreed. I do like it very much. But also that we should stop talking about this. I think still is fascinating case not from a perspective of ownership or authorship, but from the perspective of the data set. So let me tell you the story. This is Edmond de Bellamy. It was sold in an auction for $400,000, et cetera, et cetera. What's interesting is that obvious, this is not the only painting. They created a family of paintings, all right? What they did was they used a generative adversarial network to produce the family of portraits. Now, what's interesting is that the initial GAN software, and that's why I made that slide at the very start, telling you all of the all of the different things. The initial GAN was made by Ian Goodfellow, I think 2015 or 16. I didn't include a note on that, but you know, it was relatively recent. Okay, someone took that. Everyone has been using the Ian Goodfellow's algorithm and code to create their own versions of GAN. So there is GAN for portraits, there is GAN for music, and all sorts of ways of using this. Now, Robbie Barrett, he was a researcher at Stanford. He took the implementation of the software. He tweaked it because it's under an open source software license. Actually, it's MIT license, I think, or one of the most permissive open source software licenses out there. And he used that to train it with out of copyright, with public domain portraits. And he created his own version. Obvious used this, and they used different input, but they used pretty much all of his work. And they were asking questions. Oh, can we use this? Can we use this? Et cetera, et cetera. And they say he was happy to help them until they sold the painting for $400,000. And then he went like, what? But I yeah, he did it for free, and he didn't get any money, and he started thinking, oh my God, could I sue them? So lots of people on Twitter started telling him, yeah, you should sue them, they're French anyway. So I was the only person that was defending Obvious for various reasons. First, I'm an open source software geek. I told him, first of all, the software is open source. So any way you look at this, all of the training and all of the data sets are public domain. You have no ownership idea because it's all open source software. You could make an ethical claim, but not a legal claim. So they were very happy. They followed me on Twitter. I want to meet them next time I'm in Paris. But so far, it's a really interesting case. So there was a lot of confusion, and when people were talking about this, there was lots of confusion of data set, software, the algorithm, and the images, and the output. So everyone kept saying the image is infringing the copyright of Robert Barrett and Ian Goodfellow. And I say, no, they're not, because training an AI is not protected by copyright. Just training something is not protected by copyright. So my idea has been that to defend them and to say that it's not an infringement. They haven't been sued yet, so that's always good news. The data set is composed of public domain images, and the data output, the portraits, may not even have copyright in Europe. I would argue that they could have copyright protection. I'm in the minority here, so, but I would argue that they have done enough to meet the originality standard, which is intellectual creation that reflects the personality of the author. And this, I think, reflects the personality of the authors. Whatever you may think, there has been a process of selection of the portraits, and there has been a process of something that, even if you argue about the value, the artistic value of this, I think that they have done enough for copyright protection, but I'm in the minority here, okay? So that's clear so far? Questions? Okay. Case study number 4, the one I was telling you about, GPT-2, is a predictive text tool. This is actually the screenshot of the 345 million parameter data set. The one that they just released is 1,500 million, or 1.5 billion if you use the Anglo-Saxon way of counting. It is a lot. It is good, and I showed you the text. So this is the tool that produces that text now. This is an interesting question, because it's a tool created by OpenAI. These are one of the forerunners in artificial intelligence research. They have created the Dota 2 player. If you're into Dota 2, the Dota 2 5, or no, sorry, the OpenAI 5 that they have beaten one of the top teams. I think they beat OG, who are the international champions for 2 years running. I know my Dota 2, by the way. Yeah, I'm a big fan. I like OG, but Liquid is my team. Okay, anyway. The full index was scraped with text. So they put pretty much like an indexing spider, and they went to scrape text from different websites. What makes it unique is that they used Reddit to curate the links. So they got 8 million websites, but the 8 million websites is not just any random websites. It's websites that had at least 3 karma on Reddit. So that the idea is that it gave them a little bit of quality in the inputs, and it's fantastic. It's really, really good data set. It is going to change everything, I think. copyright question is that is this copyright infringement? A few people have been grumbling that a lot of the work contained is copyright protected, but I ask you again, does it fulfill many of the requirements for copyright infringement? I don't think so. It's not commercial in many ways. It's not in direct competition with the websites. If my website was listed here, I don't think, should I sue them? Yeah, I don't think so, yeah. Does anyone agree or disagree? I don't know, yeah?
Yeah, you mentioned. You've mentioned Reddit. Perhaps most of the data set comes from Reddit. Or
No, it's links. No, it's not from Reddit. It's links linked to from Reddit.
Oh, okay.
So it's outgoing links from Reddit.
But perhaps you could.
Yeah, like one of those that tell you you're leaving Reddit.
Ah, okay.
Yeah.
Okay. I see. No, because what I thought was maybe like check the terms of usage of the websites from where the text come from. Like if it's a blog, when you post this is going to be public, and other people can link to that, and etc. etc. Yeah,
my guess is that at some point someone is going to go through the text and they're going to sue OpenAI just because their website was contained. This is, I don't know. I think that this is just going to happen at some point. Yeah, but yeah.
But I think it's almost impossible. Which is the argument to sue him? It's like use my data. Okay, I use your data, but the output is so different. It's like you say you take a commercial advice. Yes, but it's 1 billion of data. It's like if I'm the judge, I say, come on, go back to your home. It's like
my guess is that that it's going to happen just because they have 8 million websites contained, and at some point, just someone is going to try it, but I don't think that they have a case. To be, in my opinion, I don't think that this is infringing copyright in the strictest sense. Well,
what I thought was that since what they took was so much, if they remove the little piece, that won't matter. It won't affect
exactly.
the work or the. If you consider the database as a work protectable by copyright, and then if you remove, we use this work, but this work is so tiny when compared to the other things that could be like a quotation. Essentially.
Exactly. I completely agree. It is what matters is not the individual website. It's the accumulation of 8 million good quality text websites that work with each other, and where all of these connections of text have been done. And I don't think that's copyright infringement. So another example, just to give you, I mentioned this as well. I mentioned it lots of times. Bob Dylan, also known as Folk RNN. If you Google this, the music is fantastic. They're very interesting music here. This is a recurrent neural network that is trained using 20,000 songs that come from this website, thesessions.org, where people just upload music. And this is not recorded music. It's music, annotated music, sheet music. I don't know. Música anotada. I don't know. Partituras, yeah. It's the same in Spanish. It's all partituras. So they trained it only using that. Of course, this is protected by copyright, but I looked and I looked and I looked. I cannot find any ownership of the music. Some of the music are just, sometimes they have a title and that's it. It's just so difficult to find any information about copyright ownership. There is no author listed most of the times. So it's like an entirely universe of data that exists outside of copyright. It's fantastic. So I think the researchers of this were very clever. They found a data set that is not protected by copyright, which is, or the copyright is almost impossible to discern. So the legal situation of data sets is, I don't know. My conclusion in this part is that it's better if you're working in a country that has an exception for text and data mining, or in the US or in Japan that have a specific fair use and fair dealing for data sets and data scraping. If not, I would recommend people to use licensed software, but even if it's licensed like under Creative Commons, you may be infringing a license. As I was mentioning you in the cases of the data set of diversity in faces, I think that they're dangerous territory because a lot of the licenses are non-commercial licenses. So there could be, just to be on the safe side, stay in a jurisdiction that allows text and data mining, let's put it that way. Europe could become very popular, I guess. That's what they were hoping to do, I guess. And to finish, I know I've talked, questions on this, comments? Because this is the interesting part, because now I'm going to bore you with case law. Okay, questions, breaks, song. Should I play the Techno Viking song or something like that? Okay, let's go. With the derivative works, this is the third part. The question here is pretty much. I'm reusing it, sorry, but it's my favorite cat gif by far. This is, I always use it here because it's what happens when artificial intelligence steals your job, you know? This is how you feel. Okay, anyway, let's see. The question here is very simple. Could you sue could Rembrandt, if he was alive and all of his works were under copyright, could Rembrandt sue for the next Rembrandt? And I know we were told not to look at the next Rembrandt again. I think it's still relevant, at least as a thought experiment. So imagine Rembrandt is alive, and Rembrandt is a painter. He's in the Netherlands, and the Microsoft and all these researchers use all of his paintings under permission, or they have legal access to them, and they create that. So the legal question here is, can Rembrandt sue for copyright infringement? Spoiler alert, no. I don't think so, but I think that no is not enough. So I'm going to, at least not in the UK, and I'm going to show you why. Maybe your mileage may vary, your jurisdictions may vary. I don't think that it could be possible in most jurisdictions because the requirement for infringements hasn't been met. And that is quite simply, the resulting work does not carry substantial enough part of the original to be considered infringement. Okay, so I would argue that. Why is that? Okay, what is infringement? Of course, I don't need to tell you this, but infringement is to perform one of the exclusive works, rights of the author without permission and without a defense. So is AI, when you're training an artificial intelligence, is it more akin to you listening to music? Do you know the case of Pharrell Williams and Blurred Lines? I don't know. Let's see. I promised not to play music, but I don't know. Let's see if this works. Because that's sort of a good. This is a U.S. copyright case. I don't know if. Let's see if I can find this. Let's see, Marvin Gaye. Got to give it up. I'm not sure if this is going to even play. Let's try. I hope it's not too loud. No, it's not playing. Oh, it's okay. It's a case where Pharrell Williams of Happy fame got sued, and Robin Thicke got sued by the state of Marvin Gaye for copyright infringement over a song. And they said, yeah, we listened to the song, and it was a good song, but we are not, they were influenced by this. but it's not direct copyright infringement. Okay, or is it different because artificial intelligence, sorry, not copyright is involved? Okay, infringement in at least in some jurisdictions is as follows. Generally 3 elements. The defendant carries an exclusive act of the owner. The defendant's work is derived from the copyright work. There is a causal connection. And the work or a substantial part of the work has been infringed. I'm not sure, is your test for infringement similar? No? Yeah?
The 3-step test, it is quite similar. However, in Article 47, they actually limit it to like brief pieces of work. So you cannot copy the entirety of the work.
Ah, okay. So
it kind of breaks the system because you cannot, for instance, there's the José de Oliveira Ascensão.
Yeah.
He criticizes it so much. So you cannot copy a painting because you cannot copy a small fraction of the work. So it's broken essentially here.
So we have lots of case law in Europe and the UK. So the restricted acts, it's easy. It's any of the exclusive rights of the author to copy, publish, communicate to the public, rent, adapt. So in the case of AI, what we're generally talking about is copying, so reproduction and adaptation, mostly those two. And mostly when we're thinking about the derivative work, could be an adaptation, but I don't know if there is enough for a direct connection. So the requirement that we have is causal connection, and we have very interesting case law in music on this. There is this case, Francis Day, Hunter, and Braun. It's a 1963 case in the UK, and it's about music. I've never heard it. This is what it looks like. Apparently, the lyrics were very similar, and it was arrived to independently. What that means is that there has to be a causal connection, a proven evidenced causal connection, because sometimes we may be influenced by the same music. If you grew up in the 80s and you like The Cure and you like Depeche Mode, chances are the music that resulted was going to be Depeche Mode like music. If you're in Latin America, you grew up with Soda Stereo, your music was probably going to sound like Soda Stereo, etc., which in its turn sounds like Depeche Mode and The Cure, etc., etc. Sorry, Soda Stereo fans. Okay, there has to be it's not just that 2 people arrive to the same conclusion. It has to be proven that they're knew about it. So we have lots of cases, and this is a really interesting case in the UK. I don't know if you can see this is a case of floral designs that were protected under copyright. The one on the left is the original. It's a floral design, and the one on the right is the infringing, the defendants. What they did was reverse the colors, right? It was considered to be an infringement. And why? Well, it's substantial copying, but also it was proven in court. They said, yes, we knew the original design, we liked it, and we just reversed the colors. So there was a causal connection. We have a European case on this. Infopack is very important, but what you need to know about Infopack is that small copying, cumulative copying, small copies of a work could be enough for substantiality. Sorry, we're in substantial use now as well. It could be enough for substantiality. So you can copy just little bits of a work, but if you copy enough little bits consecutively, you could be infringing copyright. Maybe that could be proven substantial. And then one of my favorite cases is Temple Island and New English Tea. This is probably because it's an originality case. The defense was whether or not the pictures were original enough to have copyright. Now, this is a fantastic case. The facts of the case are this. The work on the left, I don't know if anyone has been to London or whenever you go to London, there are hundreds and hundreds of shops that sell things like the one on the left. This is actually Temple Island Collections is a company that specializes in postcards that look like that. Is, you know, it's very English, and it usually involves something very British, like the Red Bus and the Houses of Parliament and Big Ben, etc., etc. A tea company wanted to create a tin tea version of that to sell. If you've also been to the UK, you'll see in Harrods and in all sorts of places they sell tea with cans, and they usually have a picture on the outside. So New English Teas wanted to buy that picture. And they said, we want to buy it, and Temple Island said no. They wanted to license it. So what they did is they went and they got a photographer and they got their own version. And they created their own version, they put it in a tin, and New Temple Island Collections sued for copyright infringement. And they won. Spoiler alert, yeah, it's crazy. It is a crazy, crazy case because it's almost in the borderline of idea expression dichotomy. I think lots of people have criticized it. I think one of the reasons why the court came to this decision was because it was evidence that Temple, New English Teas wanted to get that image. So if they had just done it independently, they wouldn't have. But the question was on substantiality. Is there substantial copying in that? What do you think? Is there substantial copying? Who would say there's substantial copying? Raise your hand. Yeah, if you're a jury, Temple Island loses, right? It was interesting. The court had to decide whether or not. So the angle, so let's say, although the images undoubtedly differ in their composition, elements of the overall composition of the claimant's image have been reproduced. The bus is a route master driving from right to left with Big Ben on the right of the bus, the riverside facade on the Houses of Parliament. There are some people visible, but they are small and in different places. There is no obvious traffic. The edge of Portcullis House is visible, and in the background is Houses of Parliament, etc. Yeah? Yeah, exactly. Yeah. So it could be. Based on Temple Islands, maybe if you meet that substantiality. Also, we have a few other cases. A video, 8 seconds of video is enough to confer copyright infringement. That's substantial enough. This was a cricket case, and the judge found that just the important part of a match is what matters. Okay? And of course, I'm not going to tell you about Pelham and others. I'm going to finish soon, but I don't know if anyone needs a break or questions or yeah, okay. And Pelham and others, so Metal of Metal, you've heard about this already, but it's 2 seconds, even 2 seconds could be enough for copyright infringement, but it has to be discernible. There has to be an understandable, you need to be able to discern, and this didn't happen. And well, I think it did. Yeah, the court didn't decide on the facts, but it laid the ground for what could constitute substantiality. Therefore, my idea here is that I don't think that there is enough substantiality in an artificial intelligence work. Yeah.
There is. About if Rembrandt was alive, yeah, there could be an option for him to sue, and it's by unfair competition. There was actually a similar case, not a similar case, that happened in the U.S. court in Florida, I guess, that Apple made a standard website. They were advertising their new iPhone, and they wanted to license the work from a Brazilian artist, Romero Brito, yeah, that one of the best Brazilian artists. Everybody loves him. and he said no. He had a contract with Samsung. It's like he makes pastiches of colors with random objects. It's horrible. Yeah, it's easy to find. You Google Romero Brito, it's like, oh, you understand. But essentially, he denied because he had a contract with Samsung. So what Apple did, they hired an artist to like copy the style of Romero Brito. They made the artwork, they posted it on their website, and everybody was like on Brito's account, oh man, congratulations on your ad with Apple, and it looks amazing, and etc. etc. It's like, oh wait, I never signed with Apple. So what he claimed, and eventually won because of it, was that it was actually making consumers confused when they access Apple's website and they thought, oh, this is Romero Brito's work, when even if his style is quite obvious, it was, oh, it's Romero Brito, and it wasn't.
We have passing off, which is in the UK, is the Rihanna right. So it's image rights, but it can also be used for confusion of commercial works as well. So it's being used with things that are not protected by a trademark, but things like trade dress. It has been used like there is a lemon juice that comes in a lemon, like it's a plastic lemon, you know, and then competitors say, oh, this is a great idea, so they created their own lemon with lemon juice, and they sued for passing off. There was not protected by trademark. So I think it could be similar. The threshold is a little bit higher, so there has to be a very likelihood of confusion. Maybe, yeah, maybe you could use passing off, but yeah, I like that. Thanks. I'll cite you in the paper. Yeah. You know, that there wasn't passing off at all. It was strictly a copyright question. There was a little bit of discussion of anti-competitiveness and a bit of unfairness as well, but it was entirely resting on copyright. In the end, I think that this could fall under transformative use in many countries. I don't think that, to answer my question, I don't think that there is enough substantiality in the resulting song, in the resulting work, in a work that has been trained by 20,000 works, by 15,000 portraits, by 8 million websites. So I don't think that the resulting output is going to be infringing. Maybe in very specific cases, but I cannot see it. So that answers the question. Concluding, this is from Blade Runner 2049. It's one of the artificial intelligence. I'm obsessed with Blade Runner, as evident. Yeah, it's a really, really good one. And my conclusion is there are things that we know. There are things that we know we don't know. There are things that we don't know we don't know. And there are things that we don't know that we don't know. So we have no idea. The case law is all over the place. There is no harmonization. Many of the cases that I told you may rest very specifically on the facts of a specific case. Generally speaking, I would say that that companies like Google, Microsoft, IBM are so far treading carefully because they know that under some circumstances they could get sued. So generally, I can see that they're trying to use lots of public domain works, lots of Creative Commons license works, et cetera, et cetera. So generally, I think that the answer to the question of whether or not there is liability in artificial intelligence, it's open and it may depend very specifically on your case. And thanks very much. That's the end. We are made to suffer. Thanks. I don't know. I don't know how we're doing the time because questions or yeah. Yeah. Now you've heard me for so long. I'm afraid that you're going to hate me.
Gracias.